Hi everyone, my name is Rachel Marks and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Emily Pendleton, a Texas construction lien law guru. Today's webinar's topic is what happens after I file my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Emily Pendleton.
Thanks so much, Rachel, for that wonderful introduction. I apologize, I'm feeling a little bit under the weather today, and so if you hear a little bit of stuffiness, I apologize about that, but I did not want to postpone this very important webinar to talk to you about, you've gone through all of the things you've needed to do in order to perfect your lien claim or perfect your bond claim as against a payment bond. Well, we need to know, how do you get paid? And so let's kind of walk through the next steps after you've utilized SunRay services and perfected your claims. Let's see. If there's any questions that arise during the course of the presentation, please feel free to drop them in the comment box, and I should have time at the end of this presentation to get to them. All right, so let's talk first and foremost about what lien rights are provided to you by perfecting your lien claim. So the foremost thing is that the lien provides you with leverage, which is critical, because without your lien, you have your claim as against the contractor or subcontractor based on breach of contract. But that oftentimes doesn't get you very far, especially in circumstances that I've been in way too many times, talking with clients about the contractors telling me, they're shutting their doors. They have no assets, you're not getting paid on your outstanding invoices. So most importantly, the lien gives you an additional claim as against the property owner. And the property owner is going to be liable to the lien claimant for two different sets of funds. They're going to be liable for what we call reserved funds and trapped funds. So let's talk a little bit about what those two things are. So the reserved funds is a pot of money that the owner is required to retain from the general contractor throughout the course of the project. And this pot of money grows over the life of the project and is equal to 10% of the original contract price, or if the project is still ongoing, it's going to be 10% of the value of the work performed. And so, realistically, how this works in practice is that the owner is withholding 10% of every invoice that the general contractor submits to it. And this pot of money is withheld from the general contractor until 30 days after the original contract is finally completed. And so that's why the timing requirements of sending your lien notices and getting your lien affidavit recorded in the real property records is so important, is to make sure that the owner is aware of your claim, and so that they hold on to these funds before releasing them to the original contractor at the end of the project. And so as long as you get your lien perfected timely, this fund of money required to be withheld statutorily under Texas law should be available to you, and this is what the owner is going to be liable for. So the second type of money that the owner is going to be liable for is what we call trapped funds. And these are funds that the owner pays to the general contractor after receiving your pre-lien notice and failing to withhold funds from the general contractor to ensure that the amounts claimed in your pre-lien notice get satisfied. And so if the owner happens to receive the notice but nevertheless makes full payment to the general contractor, they're going to have additional liability to you for failure to trap these funds. And so that's why we have these deadlines of sending out pre-lien notices to the owner and making sure they're fully aware of the non-payment issue that has arisen. All right, so turning back to the leverage that you now have based on your lien rights, I want to be clear on this last bullet point. The property owner's liability is in addition to the contractor or subcontractor's liability, whomever you're under a contract with, for the amount that's due under the lien. And so you've got your claims as against the upstream party that you have a contract with, whether that's the contractor or a subcontractor. And you also have your claim as against the property owner. And so at the end of the day, you don't care where the money's coming from, but both have liability to you. And those are the two entities that you're going to be seeking to recover those funds from. All right, so what can you do in order to collect from your lien? So foremost, trying to set up a call with the owner's representative to discuss payment resolution is going to be step one of my recommendation to get you paid, because at the end of the day, the owner is not happy about having a lien on their property. They want it off, and they're probably looking to the general contractor to, what's going on? Why hasn't the subcontractor been paid? And there's potential if the owner hasn't paid all the funds out to the general contractor, they may be willing to issue a joint check in exchange for a lien release. Let's get this lien off the property. Let's make sure you get paid and make sure that the general contractor pays you, and we can do that via a joint check. I've seen that work many times with certain clients. And just to be clear, to the extent you're able to work out a deal by which you get a joint check or other payment from the owner in exchange for a lien release, those lien releases are very, they try to incorporate verbiage into them. So just be sure to really read the lien release before you execute it. And if the owner insists that you release the lien before you receive the funds, just be sure that the lien release that you sign is a quote unquote conditional lien release that's contingent on receipt of the funds. And you don't sign a lien release that states you've received funds or is unconditional until those funds have been deposited into your bank account. And then one more avenue you could try to enforce your lien claim is to send a demand letter to all the upstream parties, letting them know, give it a short time frame of 7 days, demanding payment within 7 days of the amounts claimed within your lien. Otherwise, you'll be turning over, the claims to an attorney who will be seeking, in addition to the outstanding invoice payments, all attorney's fees, as well as interest payments that are due on the outstanding amounts. Sometimes that can gain traction. But short of doing, what you can on your own, last and final thing is to just go ahead, once the payment problem appears that it cannot be resolved without litigation, call your attorney. And so the next steps, once you discuss this with counsel, is to go ahead and file suit to foreclose on your lien. The deadline to file suit is within 1 year of the last day that the claimant could have recorded the affidavit. It's always really important to contact your attorney as soon as it becomes clear that the payment resolution cannot be reached outside of litigation. And I know I've said that a couple times now, but it's just really important because I've dealt with clients that, have come to me too late because the contractor has made promises and that, payment's coming, there's an issue with the owner's payment to us, or the owner's claiming defects, we just have a couple things we need to fine tune before we can get paid, and then we'll pay you. And I've heard it all, and maybe it's true, but at the end of the day, it's a hard 1 year deadline, and so you need to make sure you're acting in advance of that once it becomes clear that, maybe the contractor is just stringing you along, hoping that the time runs out on your claims. Under the Texas Property Code, in which you would file suit to foreclose on your lien, there's a provision which entitles you to seek recovery of your attorney's fees in connection with having to file suit to foreclose on your lien. And so that's just one thing to note as you pursue your lien claim. All right, so flipping over quickly to the bond claim side of things. So once you've done everything to send your notices with your sworn account statements to perfect your claim against a payment bond, and this applies to both public and private bonded projects, I've always seen it's a pretty typical response you receive back from the bond surety requesting additional information, things like your contract, your outstanding invoices, any communications that you've had upstream, those sorts of things. It's important to go ahead and respond to the bond surety's requests for additional information. But the unfortunate fact of the matter is I've never been involved in a case where the surety has made payment without suit being filed. And so oftentimes, you can go ahead and get additional information from the surety, because the surety will be requesting information from both the bond claimant and also from the general contractor to try and find out what's the payment problem. And so you might gain some additional information through the surety in terms of timing of payment, whether you can wait to seek counsel and go ahead and file a lawsuit to make a formal lawsuit as against the bond claim. But at the end of the day, next step is going to be to contact counsel. The limitations to file suit on a payment bond on a public project is 1 year from the date notice of the claim is first mailed. And then similarly with the 1 year limitations to file lawsuit on a payment bond on a private project is 1 year from the perfection of the claim. And so there really isn't a ton of time to wait. And just be sure to not miss those deadlines in order to file your claims to enforce both your lien rights and your bond rights. And similar to the lien statutes, there are provisions for providing for the recovery of attorney's fees in connection with filing suits against a payment bond on both the public side and the private. And with that said, that's all I have for you guys today. Rachel, did we have any questions?
Thank you so much, Emily, first of all, for your time today, especially being, sick. We really appreciate you educating us on this important topic. Let me see if we have any questions. So no, as of right now, we do not have any questions. However, if anyone here does think of a question after the webinar, please feel free to reach out to myself or Emily, and we will make sure to answer any questions you may have. If you will just do me a favor and go to the next slide, Emily.
Sure.
Okay, and if you guys would like to take a moment to review us on Google, we would greatly appreciate that. And the next slide. Okay, so let's talk about our next upcoming webinars with Emily. So the next one will be on Friday, September 8th. The webinar topic will be protecting your right to retainage through liens and bonds. And the next one will be on Friday, December 8th. The title will be Getting Paid Faster with Liens, Bonds, and Contracts. So go ahead and register today at sunraynotice.com/education. And if you go to the next slide. And that's all we have for you. So thank you, everyone who joined us today. We appreciate it. Emily, we really, really appreciate you. And I hope to see everyone on our next webinar. Thanks so much.
Thanks so much, everyone. Thanks, Rachel.